Thank you for visiting my channel. But before we start, please hit the subscribe button below to receive notification of future presentations. Our topic for today is Attractive Nuisance Doctrine in Torts Law. The Attractive Nuisance Doctrine states that a landowner may be held liable for injuries to children trespassing on the land if the injury is caused by an object on the land that is likely to attract children. The doctrine is designed to protect children who are unable to appreciate the risk posed by the object by imposing a liability on the landowner. The doctrine has been applied to hold landowners liable for injuries caused by abandoned cars, piles of lumber or sand, trampolines, and swimming pools. However, it can be applied to virtually anything on the property of the landowner. The attractive nuisance doctrine emerged from case law in England, starting with Lynch versus Northern in 1841. In that case, it was held that the owner of a cart left unattended on the street could be held liable for injuries to a child who climbed onto the cart and fell. The doctrine was first applied in the United States in 1873 case in which a railroad company was held liable for injuries to a child who climbed onto an unsecured railway turntable. The term attractive nuisance was first used in 1875 in Keefe versus Milwaukee and St. Paul Railway Company, a Minnesota case. The doctrine has since been adopted in other jurisdictions. In the Philippines, one leading case is Hidalgo Enterprises Incorporated versus Balandan, a 1952 case. In this case, the Supreme Court held that under the doctrine of attractive nuisance, one who maintains on his premises dangerous instrumentalities or appliances of a character likely to attract children in play, and who fail to exercise ordinary care to prevent children from playing therewith or resorting thereto, is liable to a child of tender years who is injured thereby. The owner of such premises remains liable even if the child were a trespasser. The facts of the case in Hidalgo Enterprises Incorporated versus Balandan are as follows. Guillermo Balandan and his wife claimed damages for the death of their son, Mario. The petitioner, Hidalgo Enterprises Incorporated, was the owner of an ice plant which had in their premises 2 tanks filled with water 9 feet deep. The factory was fenced, but ingress and egress were easily made because the gates were always open and there was no guard assigned in the said gates. Also, the tanks did not have any barricade or fence around them. One day when Mario was playing with his friend, they saw the tank inside the factory and began playing and swimming inside it. While bathing, Mario sank to the bottom of the tank, only to be fished out later already a cadaver, having died of asphyxia secondary to drowning. The lower court decided in favor of the parents, saying that the petitioner is liable for damages due to the doctrine of attractive nuisance. So the issue is whether or not the doctrine of attractive nuisance is applicable in this case. The Supreme Court said no. The doctrine of attractive nuisance states that one who maintains on his premises dangerous instrumentalities or appliances of a character likely to attract children in play, and who fails to exercise ordinary care to prevent children from playing therewith or resorting thereto, is liable to a child of tender years who is injured thereby, even if the child is technically a trespasser in the premises. The principal reason for the doctrine is that the condition or appliance in question, although its danger is apparent to those of age, is so enticing or alluring to children of tender years as to induce them to approach, get on or use it, and this attractiveness is an implied invitation to such children. Now, is a swimming pool or a water tank an instrumentality or appliance likely to attract the little children in play? In other words, is the body of water an attractive nuisance? The great majority of American decisions say no. American jurisprudence shows us that the attractive nuisance doctrine generally is not applicable to bodies of water, artificial as well as natural, in the absence of some unusual condition or artificial feature other than the mere water and its location. In the case at bar, the tanks themselves cannot fall under such doctrine, thus the petitioners cannot be held liable for Mario's death. There are numerous cases in which the attractive nuisance doctrine has been held to be not applicable to ponds or reservoirs, pools of water, streams, canals, dams, ditches, culverts, drains, cesspools, or sewer pools. In fairness, however, to the Court of Appeals, it should be stated that the above volume of Corpus Juris Secundum was published in 1950, whereas its decision was promulgated on September 30, 1949. The reason why a swimming pool or pond or reservoir of water is not considered an attractive nuisance was lucidly explained by the Indiana Appellate Court as follows. Nature has created streams, lakes, and pools which attract children. Lurking in their waters is always the danger of drowning. Against this danger, children are early on instructed so that they are sufficiently presumed to know the danger. And if the owner of private property creates an artificial pool on his property, merely duplicating the work of nature without adding any other danger, he is not liable because of having created an attractive nuisance. Therefore, swimming pools or water tanks may be considered an attractive nuisance if they had some unusual condition or artificial feature other than mere water and their location. Other examples of attractive nuisance include abandoned or unused large appliances or equipment or any parts thereof, unsafe edifice, unsecured or abandoned excavation areas, and any other instrumentality or appliance which may prove a hazard for minors. The heirs of children who sustained injuries or died because of attractive nuisances may hold the owner of the property where they are located for actual damages. In particular, the property owner may be held liable for all damages which are natural and probable consequences of his negligence in failing to set up safeguards against attractive nuisance. Said property owner may likewise be held liable for moral and exemplary damages for physical injuries that may be sustained by the children from the attractive nuisance. If you find this presentation helpful, please hit the subscribe button below to receive notification of future presentations. Thank you.